cards are going to be circulated with questions. I didn't want to just pose a couple of questions until we get the cards up here, of our guests, and they may want to comment on each other's remarks. But I didn't want to let Caperton go without asking him what happened after you won in the Supreme Court. What's happening with your case?
Victor, can you just let folks know that Maria DeSilva can collect some more?
Okay, great.
Well, I guess the short answer is we lost. After we won in the U.S. Supreme Court, and I think that there are a lot of people had this idea that, well, we won. And I've even got friends of mine that say, well, congratulations, I know you won your big case. The court ruled in our favor and sent the case back to West Virginia, remanded it back to West Virginia, and mandated that Justice Benjamin recuse himself. At that point, we have a 2-2 tie vote. We actually argued that it was a 2-2 tie, and the verdict should stay or should be upheld. Justice Davis decided that that was not the way that she would handle it, and so she appointed another justice to hear our case. And so we went through this again, but we were not allowed to rebrief on the third time around. So there was no rebriefing. There was no opportunity to try to defend ourselves against her 8 new points of law and her 4-part test for determining forum selection. And so we ultimately we lost that again 4-1, and it was dismissed with prejudice the final time. So we have now refiled in Virginia, and we are going to seek justice in Virginia. The scary thing for me is that if the Virginia court decides that, well, this has already been adjudicated in West Virginia, then I become essentially a man without a country. I could get no justice in West Virginia because supposedly this case should have been heard in Virginia, and if Virginia rules that it's already been adjudicated in West Virginia, I don't know where I go next. And so that's a little frightening for me. But we're in the early stages. We've just had a judge appointed after 6 months of sitting around waiting for something to happen in the judicial process. So we're in the early infancy stages of refiling.
I'd like to ask Judge Ternus, in New York, in terms of our highest court, we have a merit selection system, but no retention election. Is there any interest in Iowa to keeping the Missouri plan of dropping the retention election and moving forward on that basis?
Well, the discussion in Iowa, I think, is still being shaped by the forces that were at work in the retention elections. There was a movement in the Iowa legislature this year to impeach the remaining 4 justices. And there was also some legislation introduced, I believe, and I'm not entirely positive, it might have just been some discussion about changing the judicial election system away from the merit selection system. So Iowa's still going in the wrong direction, in my view.
I'm sorry, I'm going to just add something to that. I think that's interesting because I was in Nevada when they were having ballot to they were going to switch from, they wanted to go from judicial elections to merit-based appointments. And on my way out of town, I'm riding along with the cab driver, and I said, he asked me what I was doing. I told him that's what I come out to give a speech on. And he said, oh, that's a ballot you're talking about. And I said, yes. And I said, are you going to vote for it? He said, well, absolutely not. I would never vote for that. And I said, well, why not? He said, because they're trying to take away my rights as a citizen, just like they're trying to take away my rights to own a gun. So they've been very effective with those. That argument has just resonated throughout the country.
Let me ask Ms. Lithwick now. She did mention recusal. She's written about some of the apparent conflicts that Justice Thomas has. His recusal rules might apply in lower courts, but could it have any impact on Supreme Court judges?
not apply to them. They claim to use it in an advisory capacity. I'm not sure what that means. I guess it's somewhere between foreign law and the phone book. But so it doesn't. It's not binding on them, certainly. I think one of the interesting things about watching the fights over the judicial ethics questions at the Supreme Court, and it's not just Justice Thomas. There's been complaints about Scalia. There's been complaints about Ginsburg. There have been complaints about Kagan. If we continue to try to get everyone to recuse on when the court finally hears the ACA, the healthcare case in 2 years, there will be like one janitor at the court who's not recused, because everyone's trying to bump the other side off this case. And I think one of the things that is really interesting to me about the recusal rules is the way in which the person who is worst situated to decide whether he or she is compromised is the person who is making the choice at the court. And again, I would loop back to what I said about Justice Benjamin. I think the court gave him the benefit of the doubt in Caperton and said he really searched his heart. He thought very hard about this. He didn't feel that he was compromised. And you know what? We don't care. That's not the standard. The standard is, does it look awful? Do you want to be the litigant who walks in there and has a justice who clearly is in the tank for one side or the other? And so it seems to me the real flaw at the Supreme Court level, and we are seeing it play out. Now, I don't want to fight about Ginny Thomas and Liberty Central or Elena Kagan and whether she was too intimately involved in the Solicitor General's office on the healthcare debate. The point is, the worst situated people to decide if they're biased are the people who are biased or allegedly biased. And it seems to me that's the real problem we're seeing play out at the Supreme Court.
Now I'm going to try to do justice to these cards. I know I'm not going to do that goal, but I can't resist leading off with the following. Okay, panelists? Citizens United is damaging to our democracy. What should we do about it, other than stand by and watch? How reverse its consequences?
I'll just start by saying Citizens United is rooted, Justice Kennedy's opinion in that case is rooted in the idea that strong disclosure exists. And Kennedy, I think, really deeply believes that he wrote an opinion that said there will be very, very strong disclosure and transparency. The system can't work otherwise. So I think as an initial matter, we need to really ask ourselves how it is that in the year and a half since Citizens United, disclosure has become subject to debate in this country. And the disclosure rules are now something we're fighting about. Maybe nobody should disclose. After all, people could boycott your business and make you feel bad. And so we're having a complete paralysis now over serious enforcement of the disclosure rules. And it seems to me that just as a starting matter, campaign finance reform can't work, even post-Citizens United, without proper disclosure. I think Hugh Caperton couldn't have found out what he needed to find out absent disclosure. So it seems to me that's a very, very immediate and urgent starting point that we seem to be seeding in the public debate.
Any other comments on that?
Well, I think the debate ought to be whether there should be elections at all in the judiciary. I don't see how judicial elections, regardless of any kind of campaign disclosure or limits on campaign contributions, can be productive of an independent judiciary over the long term.
I totally agree with it.
I just want to add that the Federal Disclose Act went down by one vote. That was not for judicial elections. Went down by one vote last year. No Republicans voting for it. But people who wanted full disclosure. However, these are state issues, and there's no reason why states can't, who elect judges, can't adopt strong disclosure rules, and that's something that people ought to, I think about. Then there's recusal rules. We have in New York, thanks to the leadership of our chief judge, there's a rule coming that will prevent cases from being assigned to a judge who's received more than $2,500 from a party or a lawyer within 3 years, within the past 3 years. It's not perfect, but it's a major step forward, and I hope that other states will follow along. But you know, we don't have to wait. None of these state elections, none of these judicial elections are federal, because no federal judges are elected, so that this can be dealt with progress at the state level. Here's a question for Justice Ternus. Suppose the decision in Iowa was against gay marriage, and liberal gay rights groups worked successfully to throw out anti-gay rights judges. Does that change anything in your view? Why not? Why and why not?
No, because it's still a special interest group issue-based decision intended to influence and intimidate.
Okay. Why bother making the distinction between the judiciary and the legislature? Why should they not both be held to the same high standard?
What high standard is that?
Cat's been out of the bag with politicians for a long time. I don't know if we'll ever put that in the bag, back in the bag. But I think we have to hold the judges and justice to a higher standard. And you know, I think the thing in West Virginia is, you know, we have recusal rules and we have disclosure rules. They got to be followed. I mean, they have to be followed, and they have to be. I agree. I think they have to be taken out of the hands of the person, the judge or justice in question. And frankly, I'd like to see it taken out of the hands of the entire court, the Supreme Court, and put in the hands of some type of a recusal commission, because there's too much politics that's going on within the court. So I know that in my case, if they would have put it in the hands of the 4 other justices, I wouldn't have felt comfortable with their decision at that level either. So.
And I would just add, maybe this is just a slightly less flip way of saying the same thing, but I think it's so important. Polls consistently show that the most esteemed branch of government, by a lot, is the federal judiciary of the 3 branches. Even though there's an enormous amount of kvetching about how they're elite and they're out of touch and they're imposing their values on the rest of us and they're taking away our freedom, as compared to the other branches of government, they consistently are ranked higher. And I think that is because they hold themselves to these high standards. So this isn't sort of just flippant, conversation about how gross the elected branches are. I think it's also, and I guess it goes back to what I said initially, I think there is a profound belief that most judges are doing their jobs, they're working in good faith, they're trying to do something different from what the elected branches do. And I think that as a consequence, just one other data point that I'll throw out because I think it's useful. When you ask Americans which of the Supreme Court, of the 9 justices on the Supreme Court, they trust the least, it's invariably those who speak the most. So the ones that make Americans very nervous are the ones who are out on TV and in op-ed pages and writing books about how they decide cases. I think we actually, and I think this goes to the Justice Ternus's point about we don't want to answer back. We don't want to get into the fight and take the gloves off and start yelling at these groups, because there is something about that mystification, and I say mystification not in a derogatory way, but there is something about the judiciary not screaming and pulling hair and kicking the other side that is the reason that we revere it. And I think that to really diminish that by getting into fights and getting into the fight is to disserve the judiciary.
I think a point you made earlier in terms of teaching Americans the role of the judge and the role of the legislature and how they differ goes back to civics education. They do entirely different things. And I know it's fundamental and long-term, but it's vital. Is there any evidence to suggest that the same issues or problems don't exist in states in which judges are appointed?
Well, I am a state where judges are appointed. So, I think that what that question, I think, signifies to me is, well, aren't there problems in a system that doesn't have politicized elections? Well, of course. I mean, there is no perfect system. And if we're going to resist change or even resist discussion until someone proves that they've devised a perfect system for selection of judges and retention of judges that cannot be ruined or hijacked, then that's never going to happen. Because any system is implemented by citizens, whether it's a commission or a governor or the voters. And if we don't believe in a judiciary with integrity and one that shouldn't be intimidated or influenced or appointed for ideologies, then it's not going to happen. And so it's our decision. I think the system that we have in Iowa is least susceptible to being politicized because we don't have political style elections. We're appointed on a commission-based, merit-based system. But it doesn't mean it's perfect. Just like something you said reminded me, I often say, just because judges have integrity, even judges with integrity who make decisions based on the rule of law, doesn't mean you're always going to agree with them. And it doesn't even mean they're always going to be right. Because no system is perfect, and no person is perfect. But as a society, we have to move toward a culture of believing in the integrity of the judiciary and the need for an independent judiciary so that people can trust in the court system. And until we all invest in that and believe in it, it won't happen.